Welcome to this Texas Public Policy Foundation live stream discussion about judicial DOGE, why TPPF's upcoming Supreme Court case attacks the unfettered discretion of the executive branch. My name is Robert Henneke, and I'm the Executive Director and General Counsel of the Texas Public Policy Foundation. I'll introduce in a second my co-counsel, Trent McCotter, for have a great discussion about the upcoming Supreme Court case of Federal Communications Commission versus Consumers Research. As many of you watching remember, 10 years ago, the Texas Public Policy Foundation created a litigation center, the Center for the American Future, within the foundation, recognizing that so much of what we consider policy is not being made in the legislative branch. It's being made in the executive branch. It's being made in the judiciary. And by not having a constitutional public interest litigation center, so many of the important liberty fights TPPF was being left out of. And not only was the goal then to litigate those cases on behalf of the foundation, but to also partner with amazing conservative legal litigators like my co-counsel to be able to bring these questions forward with the goal of winning cases that don't just benefit our client, but to set precedent that claws back the administrative state as we don't just put government back in the box, but we make that box smaller. And so we have an amazing case to discuss with you today that in 2 weeks, the Texas Public Policy Foundation, along with the Boyd & Gray law firm, will be before the Supreme Court arguing this case. And so here in a minute, we'll just talk to you about what to watch and why this is the most important case on the Supreme Court's docket this year. But first of all, allow me to introduce my co-counsel in the case, Trent McCotter. Trent will be the lead counsel arguing this case before the Supreme Court. He's currently a partner at the Boyd & Gray law firm. Prior to that, served during the first Trump administration in the Department of Justice. Trent's had an amazing legal career, clerking for 2 federal courts. He's a double graduate of the University of North Carolina and is no stranger to these major change the world type victories. You've probably already heard of the recent win that Trent and his law firm had in stopping the emergency stay of the Security and Exchange Commission's climate disclosure rule. So this is going to be another big change the world type outcome and argument and case. Trent, it's a pleasure to have you with me. So thank you for being with us, and thank you for being in this partnership with TPPF for the upcoming case. So welcome.
Thanks, Rob, and thanks for having me. Appreciate it.
So start off, if you would. I love the quote that you included in the beginning of the brief that we filed with the Supreme Court that talks about how an indefinite power to tax is a power to destroy. And that's actually quoting the United States Supreme Court's 1850 opinion of Nathan versus Louisiana. And when we talk about this Federal Communications Commission versus Consumers Research case, first of all, start with me and just explain big picture. What are the facts of this situation? What is this case about? Before we then kind of move into what legal issues are in play.
So at its highest level, the case is about taxation without representation. Who decides what taxes we pay? Is it Congress, the people that we elect? Or is it agency bureaucrats, or as we'll discuss a little bit later, even private individuals who have an interest in the particular subject matter? So in this case, we're challenging the Universal Service Fund. It's run by the Federal Communications Commission. That's a federal agency that's housed within the executive branch. The USF, as we call it, collects about $10 billion every year. It's paid initially by telephone companies. There's about 5,000 that pay into it. They then just immediately pass it along to customers. I can almost guarantee everyone who's watching right now, if you go look at your cell phone bill, there will be at least one and maybe multiple line items for Universal Service Fund, or Universal Service Fee, they call it. So it doesn't sound so bad. That money gets collected and then spent to benefit ostensibly expanding telephone service, expanding internet service, that sort of thing. Laudable goals, everyone agrees. The difference is, unlike every other tax, that the federal government imposes. Think about your income tax or Social Security tax. Here, Congress itself did not say what the tax rate would be. It didn't say you tax 25% of a particular number. It didn't say raise $1 billion a year so that we can fund this program. It didn't do any of that. It said, hey, FCC, Federal Communications Commission, how about you raise enough for universal service? So that's the first problem with the way this program operates. There's really no limit that Congress imposed. But then to make it worse, Congress told the FCC, raise money for this program based on these principles. And the principles are kind of euphemistic type things, tautologies to talk about universal service is good. We want people with lots of service. Service should be affordable. And these are all things the FCC kind of at most must just think about. They don't actually have to influence the FCC's decision. Add that together. And then even universal service itself, you might be thinking, what does it even mean exactly? It's a good question. In fact, Congress decided that they didn't want to decide. They said, FCC, you get to define universal service based on an evolving standard. So put it all together. Congress gives the agency the power to raise taxes to pay for this social welfare program, except there's no limit, there's no cap. The principles are aspirational only, and even the core definition of the entire project, universal service, is not provided by Congress. So that's the first part. You think that alone is bad enough, and we argue that alone is unconstitutional. But then, getting back to the logistics, you have the FCC handing over a lot of this power to a private company. It's called the Universal Service Administrative Company, USAC, USAC. It's run by, this is on their own website. We didn't have to make it up. It's run by industry interest groups. It's all telecom individuals. Some individuals I think are professors, but mostly they're insiders in the telecom business. Each quarter, they make a proposal, and it says essentially, here's how many billions do we think will be needed for the next 3 months for universal service. The real kicker is, if the FCC does nothing, that proposal goes into effect. And that is, in fact, the tax rate that we all end up paying. Like, surprise, surprise, over 25 years, the FCC's never really changed USAC's numbers. In fact, as can be seen from this process, the FCC doesn't even really want to be bothered by it. So every year, about $9 to $10 billion gets raised for universal service just by default. Like, nobody really knows how it happens. Did Congress say so? Did the FCC say so? Did USAC, this private group, say so? A lot of that's by design. So
that's incredible.
To blame.
Incredible. And I can imagine that a lot of our viewers that are watching this right now are finding and pulling out their cell phone bill and scrolling down. You got so many, fees that are on that. But right there, I imagine that most everyone's going to find this universal service fee that we pay every single month that is at what is issue in this case. And let's not gloss over, I think with some of the discussions recently, a billion here, a billion there, it seems to add up to real money. $10 billion is generated under this fee or this tax that Congress never authorized, that every single one of us pay. And then it sounds to me like you're describing almost kind of like a slush fund that the telecom entities choose how much to tax each of us, and then they get that money and they get to hand it back out to themselves then on how to spend that. So it's not just that Congress never gave authority to explicit, but that then you have this like private coalition of the industry players that then get to like decide how much and then hand it out to themselves. So it's almost kind of like a double layer of lack of accountability that we're describing in this case.
Right, and that's what the case is about, what we call non-delegation principles, essentially the idea that Congress can't delegate away to other people its own exclusive important powers, like setting taxes. But the reason we have this principle is so there's clear accountability. And the ultimate objective of this fund, sure, is to try to increase telephone coverage and that sort of thing. But along the way, because nobody really takes responsibility for it, nobody really knows who's to blame for it, people view it as these are the words of others, a big candy jar, free money. And so there's enormous waste, fraud, peculation is one of the terms, self-interest, self-dealing. Granted, we all know even when Congress does taxes, you're going to have some of that, pork barrel spending, that sort of thing. But the thing is, at least then you know who to blame. You know this is Congress's fault, and you can vote against them if you want and get rid of them. But for the Universal Service Fund, you can't vote out USAC. They're just private individuals. You can't even vote out the FCC because they're not elected either. And so when we talk about like the big picture, like why does it really matter? You're right, it's $10 billion a year, not chump change. But the principle is even more important. The principle that when it comes to spending money, raising money, that sort of thing, and even just making laws generally, there needs to be accountability. So at the very least, you know who to blame when you don't like it.
And it seems, Trent, it seems to go to kind of civics 101. I mean, we're going back to the basic principles that the founding fathers had when they wrote the Constitution, when they enacted it, and how they designed it, with, the intent being that the most accountability was to be with the legislative branch, because the most power that Congress could exercise in setting policy and passing laws that restrain your liberty and taxing you. And so, conceptually, that's why the founding fathers made the legislative branch an elected branch, and you had the House and the Senate, and by design there was to give the people a voice in there. This whole concept seems to thwart the basic premise of separation of powers that have existed when Congress basically hands off the decision making to unelected bureaucrats or people that are even in the private sector.
That's right. And those who know a little something about English history will think back to the days, obviously many centuries ago, where English kings would try to just raise money directly. A couple of kings were executed because they were a little too aggressive in trying to get money from Englishmen without Parliament's consent. And it's interesting when you go back through the historical documents, I won't go through them, I know that nobody wants to hear about that, but the general principle was Parliament, or our version now Congress, is created first and foremost to raise money and to check the executive branch. And only after that came the power to issue what we think of as more normal rules, laws, regulations, that sort of thing. The initial power was always control the money. If you could control the money, then you can control the executive, the king in England, or the president in the United States. And so this is not just a legislative power. It's not just something that's important to ensure is decided by the elected branch. It's actually, in our view, like the most important power possible. And going back to the very first thing you let off with, Rob, that quote from the Supreme Court, that's why the Supreme Court has said for 200 years that the power to tax, especially the indefinite power to tax, is the power to destroy.
It seems to me, though, that this case is obvious, that it's, nothing is ever so simple, but it's almost a no-brainer that, you can't have an executive agency doing something that Congress hasn't specifically given them authority to do so, especially when it comes to assessing taxes upon the American people. This non-delegation doctrine that you mentioned, Trent, but this case, this issue has not come up in front of the court in a long time. So even though it seems basic and obvious to probably a lot of those that are watching with us, explain for me the bigger picture of why the court taking this case and being willing to consider the non-delegation doctrine is so important, and why so many legal scholars are calling this case the most important case on the Supreme Court's docket of this year.
So the Supreme Court has had probably 15 cases over its entire history that deal with non-delegation in some way. For a while, the first 150 years or so, they policed the boundaries pretty strictly. They would say these are exclusively legislative powers, or these are powers that are kind of shared between the branches. We're not so concerned in those cases if Congress gives a little more broad power to the executive. But in recent cases, the Supreme Court has addressed situations that are arguably just purely executive, and the court has imposed a test so broad, so flexible that essentially nothing violates it. Now, we still argue that the situation does, but ultimately, the Supreme Court, a lot of people think, has kind of gotten out of the game of non-delegation. And if that's the case, then having a chance here to reinvigorate the doctrine and have the court adopt the standards that it used to 200 years ago is a real golden opportunity for us. So many cases have come up in the lower courts. So many cases have tried to get up to the Supreme Court to change this framework. And by and large, they failed. Now, to be fair, there was a case about 7 or 8 years ago that involved the Attorney General essentially defining crimes. You would think if ever there were a non-delegation problem, maybe besides taxing, that's one, having the Attorney General decide crimes. And the court kind of dodged there. There were enough votes to say, well, if you read the statute a certain way, we can maybe avoid the idea that too much power has been given to the executive branch. But 3 justices, Justice Gorsuch, Justice Thomas, and Chief Justice Roberts, dissented in that case and said, we really need to rethink non-delegation here. We've been doing it wrong for the last 80 years or so. We need to return to the old days where you could decide whose power is this, and the court would police that line. And it matters, like we said, because so many things that Congress should be deciding under the Constitution are ones that agency executive bureaucrats are deciding, unelected individuals. All these rules and regulations, there are thousands of them out there. Most people have never even heard of them. The rules about what kind of cars you can buy, what kind of hot water heaters you can buy, all kinds of restrictions on stocks. Essentially every aspect of our life, of our lives, is influenced by these sorts of agency rules and rulemakings that a lot of times trace back to really broad delegations by Congress, because Congress kind of didn't want to take responsibility for it. So the case presents an opportunity, depending how the court rules, obviously, for Congress to kind of reassert its primary role in deciding that the basic rules of life in the United States, which by and large now are not set by Congress, are actually set by agency bureaucrats. So it's not just universal service, it's not just taxation, it's not just private party involvement. Like, the case sets the stage for addressing all of these sorts of problems that people complain so much about, kind of a feeling of helplessness, a feeling that their legislatures don't answer to them, that the legislatures don't respond to them. A lot of that traces back to delegation.
You know, and it strikes me that a Supreme Court win in our favor in some ways will command Congress to do its job. And you think about in the fact pattern of this case in a different context and why, you know, this is another way this is so important. But that, let's say that Congress had passed a law saying we're going to put a fee, we're going to put this tax on everybody's cell phone bill. That would be unpopular. I would not like that. I think a lot of citizens would not like to see their member of Congress vote to add a tax onto their cell phone bill. So they've hidden it. They've used this vague language and allowed the Federal Communications Commission to do this and to delegate it, because this has been going on for a long period of time. It's not something that had just happened yesterday. And so when we win cases that stop this type of unlawful delegation from happening, then that puts the onus back to Congress to say, hey, Congress, do you want to pass this tax that's going to, you know, raise $10 billion from people's cell phone bills? Or maybe that's not the best policy. And pulling that out, Trent, I wanted to ask you in a bigger sense, you know, a Supreme Court win on this case with the non-delegation doctrine that you describe. In current events, we're seeing a lot of news right now about the DOGE Commission and the work that Elon Musk is doing in identifying these fraudulent and wasteful contracts and these agencies that have been acting, you know, rogue and handing out billions and billions and trillions of dollars there, you know, without congressional approval, even though Congress continues every year to continue to fund these agencies. But how would a win in this case potentially provide the vehicle and tool to address those other issues where we want to restore the branches of government and to make sure that Congress is the one exercising its authority under the Constitution.
Right. So on the DOGE example, a lot of people think, like, how could the agencies ever have gotten into this situation in the first place, giving out all this money or setting all these programs, things like that? And you're right that sometimes they're not allowed to do it. They violated statutes, I think, in doing so. But in a lot of cases, these agencies operate under extremely broad delegations of power. Congress doesn't want to take responsibility for imposing taxes, right? And so how do you get around that? You give it to an agency and then you call it a fee or a contribution or some kind of euphemistic word. And how do you also ensure that nobody really pays too much attention to it? Well, give the agency the power to kind of just make up how much they want it to be. That way you ensure the agency never even has to come back to the Congress to decide how much money we need. So for example, like the Universal Service Fund is started out every year raising about $1.5 billion, maybe $2 billion a year. Certainly not a small amount, but certainly not a limit imposed by Congress. Like, surprise, surprise, after 25 years, the number is almost, 8 or 9 times higher than that. Under the normal operation of things, if Congress had said, FCC, you can go raise $1 billion a year for universal service and do it by a tax on cell phone bills, then people would know, okay, Congress imposed this, we know what the limit is. And when the FCC runs out of money, they're out of money, right? They can't raise anymore. They can't give out anymore. Like these agencies, they have all this money, and it's like, aha, the way to get around that is to just not put a limit. Don't put any requirements. And that way the agency can turn around and just keep raising it forever. Some people have said these sorts of programs operate on autopilot. I think even that's honestly kind of too charitable, because when a plane's on autopilot, it doesn't decide for itself where it wants to go. You kind of set it and forget it. But here, there's not even a set it, right? The agency is just given all this broad power. Compare that to other contexts, like you say, not just raising money or spending money, but all these rules and regulations. We saw a lot of it from the last 4 years. Rules about electric cars, rules about hot water heaters, rules about hospital treatment, like everything you can imagine that goes on, federal agencies will try to regulate. And how do they do it? They point back to some statute that just says, do something in the public interest. Whatever you guys think should be done, go for it. And that's how we end up with such unaccountable rules and regulations, honestly, ones that are widely unpopular outside of DC and New York. And you wonder how this happened. They certainly wouldn't have happened if Congress had to set them.
That's right. That's right. In many ways, Congress has ceased to act as a, co-equal branch of government. But, in the extreme sense, thinking of how, this month 5 years ago, in many ways, was when the COVID pandemic began within the United States. And you think about extreme examples that we lived through as Americans between the airline mask mandate and government shutdowns and vaccine mandates and other policies that were imposed then. The same kind of principles apply under the non-delegation doctrine as in this case, that these vague grants of power by Congress can be abused, have been abused. We've seen that, we've felt that in our lives. Even though the universal service fee may just be a couple of dollars on your cell phone bill, the bigger principle really addresses liberty and how we can protect ourselves against an executive branch and a federal government that is all too willing, whether it's how you travel or medical health decisions or how much money you pay for your monthly cell phone service, to take those powers and abuse them if these checks and balances that are hard written into the Constitution aren't affirmed and enforced by the courts. Let me ask you, changing gears real quick. But Trent, this is your first Supreme Court argument, even though you've had many, many, many appellate arguments in the federal courts at the appellate level and the trial court level. So twofold. One, what are you looking forward to this? And, what is this going to be like for those in our audience who've never been to the Supreme Court? And kind of how do you feel that the justices are going to respond to this case? Take me through what you feel that, the day of the morning of on March 26th will look like, both in terms of a career milestone for you, but then also what we expect the court to do or to say in response.
So the argument will be on March 26th at 10 a.m. or perhaps a little bit afterwards. They might have some other business to handle right before the argument begins. There will be a live feed on the Supreme Court website for folks who want to listen in. As I said, if it doesn't start immediately at 10, don't panic. It'll start soon enough. The logistics of it, the other side will go first, the government. They also have some interveners, we call them, essentially companies who get money from the Universal Service Fund are also supporting the government, unsurprisingly. They will go first because they lost below. We actually won in the lower courts. Then I will get up. Technically, each side has only 30 minutes. However, a lot of arguments at the Supreme Court run long. We're the only case set for that entire day, so I suspect the justices will use as much time as they want. What I'm most interested in, as you say, it's my first Supreme Court argument. It's an interesting experience, but actually what I'm most interested in will be to hear some of the questions that the justices have. They don't always tip their hand. Sometimes they'll ask the hard questions to both sides. Sometimes they'll ask the same question to both sides. But you can often get a sense of what some of them think. Some of them have a stronger poker face than others. As I said, there's a couple of justices who wrote 8 or 9 years ago in a different case about non-delegation. We generally know what they think, at least about the principles. But there are a few justices where we don't really know what they think. Some of the newer ones have not had any opportunity to write on any of these principles. So Justice Jackson, the Biden appointee, Justice Barrett, even Justice Kavanaugh, who was a longtime appellate judge and had a lot of cases about separation of powers, we're still not really sure exactly what they think about non-delegation, let alone applying it to this particular case. So that's what I'm most interested in, is just hearing their questions, trying to see, like, hopefully some of them agree with us. Hopefully they're asking questions that express some skepticism of this idea that Congress can just hand over its taxing power. We led off our brief with an example about the IRS, essentially saying, imagine the IRS did all of this rather than the FCC. And you mention the IRS and immediately everyone gets it, right? Like, imagine the IRS could set tax rates, just whatever they want, essentially. And it's an outrage and people immediately realize it. Shouldn't be any different because it's a different agency. It's like, are the justices getting that? And if not, like, what questions do they have that I could then address when I stand up? If Justice so-and-so, you had a question about this, actually, let me tell you about why this is such a problem. And so that's what I'm really looking forward to. In terms of what the court will actually do in the end, who knows for sure, to be honest. As I said, it's hard to predict because the court just has not had that many non-delegation cases. Also, as we've discussed here today, there are a lot of avenues the court could take. There's a lot of problems with the statute itself. Is the statute too broad? Could the statute be fixed? How does the court address that? You've got the involvement of the private company. Is that itself a constitutional problem? We argue it is. The court below found that they thought it was, but they didn't necessarily have to say, because there's a third option, which is how the court below ruled, which is that the combination, essentially the statute's too broad, and then you give all this power to the private company, combine them, and at the very least, that is a constitutional problem. Will the court be interested in that? That's another option that could go down. And so, like, it's hard to say what the ultimate outcome could be. We're really hoping for a victory that kind of reorients non-delegation along the lines that the court had used for 150 years, just until about the 1940s. Suddenly they kind of switched and became ultra-deferential. We're hoping for an opinion that outlines those principles, really hoping that some of the newer justices will tell us what they think. Obviously, we're hoping for a big victory. We won below. 9 judges on the court below agreed with us on this. And so we've got we've got tailwinds in our support. We brought another lawsuit that is kind of tangential to this one in a different court. One of the judges there, a very respected judge on the 11th Circuit down in Alabama, he wrote a concurrence essentially saying, the challengers, us, are right about everything. It's just the Supreme Court needs to change the case law. And if we could just get the court to change the case law a little bit, change the standard, this is like the easiest case you'll ever get. The idea that you can't have agencies setting tax rates. So I'm really hoping all that comes through in the argument and ultimately in the opinions. As for the ultimate vote, nobody knows, right?
That's right. Well, stay tuned on that. March 26th will be the argument, and everyone in our audience can listen to the live stream of the audio. Then we'll have an opinion from the Supreme Court by the end of June, so stay tuned on that decision. But Trent, the Boyd & Gray law firm has been such an extraordinary advocate in this case and shepherding it all the way up to the United States Supreme Court, and you've done such an amazing job in leading this case. So thank you so much for being the lead counsel on this and for Boyd & Gray's partnership with the Texas Public Policy Foundation as co-counsel. Stay tuned. Best wishes on the argument. We're going to conclude the live stream here today, but I hope everyone will follow the case, follow the arguments, and know what's at stake as we wait for the 9 justices to tell us what they think. So a great discussion here today. Federal Communications Commission versus Consumer Research. Put it on your radar. It's coming up soon, and it will be the most important case of this Supreme Court term. So, Trent, thank you so much for taking the time out of your argument prep to join us, and we're excited for what this case is going to bring.